Be ready, 5 seconds. The captioned writ petitions lay challenge to the provisions of Section 271 1B of the Income Tax Act 1961, hereinafter referred to as the Act, on the ground that it is ultra vires the Constitution of India. The impugned provision, which was brought on to the statute book by the Finance Act 2008 with retrospective effect from 1/4/1989, has resulted in a grievance insofar as the petitioners/assessees are concerned, inasmuch as, apropos to its insertion in the Act, the salutary requirement of the assessing officer arriving at his own satisfaction during the course of assessment proceedings that the assessee has concealed the particulars of his income or has furnished inaccurate particulars before initiating penalty proceedings has been done away by a deeming fiction encapsulated therein. This, in short, is the kernel of the controversy before us. As is evident on a bare reading of the provisions of Section 271 1B of the Act, that the deeming fiction envisaged in the said provision, which is to operate retrospectively, pertains only to clause C of subsection 1 of Section 271 of the Act. Consequently, the writ petitioners before us have made the following main prayers in their respective writ petitions. Writ petition number 5059/2008, that the impugned subsection 1B of section 271 of the Act may be struck down as constitutionally invalid, or alternatively it may be read down to the effect that the satisfaction should be deemed to have been recorded only where reasons are specified with respect to specific items of additions or disallowances leading to the initiation of penalty proceedings. Writ petition number 6272/2008, a writ of certiorari or writ, order or direction in the nature of certiorari or any other appropriate writ, order or direction under Article 226/227 of the Constitution of India, quashing subsection 1B to section 271 inserted by Finance Act 2008 as arbitrary, ultra vires and violative of Article 14 of the Constitution of India. We had called for ITA number 548/2006, which is an appeal filed by the department against the order of the Income Tax Appellate Tribunal, hereinafter referred to as the Tribunal, quashing the penalty proceedings in order to ascertain the bare facts, the writ petition being bereft of facts essential for the purposes of adjudication. The following facts, which are not disputed, emerge on reading of the file. Section 271 1B of the Act is not violative of Article 14 of the Constitution. The position of law both pre and post amendment is similar, inasmuch the assessing officer will have to arrive at a prima facie satisfaction during the course of proceedings with regard to the assessee having concealed particulars of income or furnished inaccurate particulars before he initiates penalty proceedings. Prima facie satisfaction of the assessing officer that the case may deserve the imposition of penalty should be discernible from the order passed during the course of the proceedings. Obviously, the assessing officer would arrive at a decision, that is, a final conclusion, only after hearing the assessee.